Host and legal analyst at Law and Crime Network, Terri Austin, for more on this. Terri, I know you've been talking a lot about this. You've wanted to talk about this, so here you go. This is your opportunity. Let's get your reaction to opening statements yesterday.
I thought all of the parties actually did a great job. I think the prosecution really laid out the case, and she is raising the standard of willfulness here. She's saying that all three of them acted willfully. We know for a fact that Lane has one less charge. All three of them are being charged with depriving Floyd of his liberty and basically of his constitutional rights by not giving medical aid. But they're saying that King and Tao also did not interfere or stop from Chauvin killing Floyd. So they're saying that Lane did try to stop Chauvin from killing him by asking him to roll over. So I think the prosecution laid it out. I think she's setting the standard. We're supposed to be acting with common sense and not just following robotically. But I do think the defense attorneys laid it out very well also.
So ex-officer Lane, as you've been mentioning, can actually be heard on video of that incident asking if they should stop and check on Floyd. And Lane's attorney has indicated in court that the former cop will testify in his own defense. So what impact do you think his testimony will make, just that audio that you can hear, as well as his comments that he made throughout that entire recording?
Well, we have Earl Gray, who's representing Lane, and his job is to separate Lane from King and Tao. And I think he started out doing a good job of that by saying, look, Lane is going to tell you that he tried to say, roll over George Floyd, make sure that he can breathe. And he also went in the ambulance with him. He tried to render aid. He called the ambulance. He asked them to increase the urgency. So as flamboyant as Earl Gray may be, he is actually trying to separate the actions of his client from the other two, and definitely from what Derek Chauvin did. And he might actually win on that point, because Lane was really a little bit different from the others, even though all of them should have intervened at some point to make Chauvin stop kneeling on George Floyd's neck.
Well, then on that point, what do you make of defense attorneys pointing the finger at Chauvin, arguing that he took control of the incident? So can these officers, the actions, be evaluated separately from Chauvin's in this case, or is that not possible?
Well, I think it's possible, and that's what the defense attorneys are really trying to do. Plunkett, who is the attorney for King, really laid out the fact that there wasn't the sufficient training, that both of the other officers were actually all trying to follow what it was that Derek Chauvin was telling them to do. Tao was, of course, standing there and directing traffic, so to speak. But King and Lane, according to Plunkett and according to Earl Gray, were just basically following what they were told to do. They were rookies. They didn't have the proper training. They didn't have scenario training. So they're pointing the fingers really basically on Derek Chauvin, but also on the police department, saying that they should have been trained a little bit better and they were only doing what they knew what to do. So I think they're trying to separate themselves out here.
Well, we're going to keep track of it all, of course. Terri Austin, thanks so much.
Thank you, Kira.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.